Hello, my name is Mitchell Schultz, and I will be discussing Title VII of the Civil Rights Act of 1964. Title VII is a section from the Civil Rights Act of 1964, and it prohibits discrimination against employees, applicants, and union members on the basis of race, color, national origin, religion, or gender at any stage of the employment. That prohibits both intentional and unintentional discrimination, and it is also monitored by the Equal Employment Opportunity Commission, or the EEOC. In early stages of the Title VII Civil Rights Act, the EEOC was not big enough to represent any lawsuits that were brought up against companies. So, in order to file a lawsuit on the basis of violating Title VII, plaintiffs had to use private lawyers for the first several years. Later, once the EEOC got big enough and got more funding and more staffing, they were able to hire lawyers on behalf of the plaintiffs and were able to represent cases later on in history. There are several cases in early history that set the basis for Title VII for further cases down the road. The first being one of the biggest, Griggs versus Duke Power Company. In this case, the challenging respondents sued Duke Power Company because Duke Power Company issued intelligence tests as a condition of employment or transfer at the jobs of the plant. The requirements were not directed or intended to measure ability to learn or perform at a particular job. It was basically just a way to deter less educated employees, in this case minorities or African American employees, from furthering themselves in the company. Because a disproportionate number of African Americans were rendered ineligible for promotion, transfer, or employment, the requirements were deemed unlawful unless shown to be job-related. They were requiring high school diplomas and intelligence tests in order to either get promotions in different departments or to be hired at all. The overall ruling on this case was that it was unlawful to issue these tests or require high school diplomas unless it was directly job-related. The next case is Meritor Savings Bank versus Vinson in 1986. This was a sexual harassment, one of the first sexual harassment cases brought to the attention of the EEOC in 1986. The plaintiff, who worked for the bank, started off as a teller and worked her way up to assistant branch manager while she was there, but throughout her time being at the bank was sexually harassed by her supervisor. The Court of Appeals reversed and remanded after the initial district court basically denied dropped the case and said that the plaintiff did not win. Later, the Court of Appeals reversed and remanded the case, noting that the violation of Title VII may be predicted on either two types of sexual harassment. The first being harassment that involves conditioning of employment benefits on sexual favors, and the second being harassment that, while not affecting economic benefits, creates a hostile or offensive work environment for the employee. This was the first case that introduced these two separate ideas of sexual harassment. Before, it was only thought that sexual harassment was applicable in violation of Title VII if it involved an economic boost or a promotion for the person that was being sexually harassed. Furthermore, the case also closed and deemed the bank liable for the supervisor's actions of sexual harassment towards the employee. Whether or not the employer knew about it, they were deemed liable for all actions of employees. And the third case is Price Waterhouse versus Hopkins in 1989. This was another discriminatory case against gender, not necessarily sexual harassment, but it was about a partner or an employee at an accounting partnership who was up to become a partner, but was denied that promotion because she was a woman. It said that she had all the qualifications for it, and she almost had the job until not enough people voted her through, and then a week later they discarded her application for the promotion. So she sued because that she was a woman, and eventually the court sided in her favor for that as well, saying that both courts, in this case, held that the employer who was allowed a discriminatory motive to play a part in the employment decision must prove by clear and convincing evidence that they would have made the same decision if there were no discrimination, and that the plaintiff had not carried this burden. So basically, if the company could prove that they would not have hired her, whether or not she was discriminated against, if they could clearly prove that, then the plaintiff would have lost the case. However, they could not prove that, so the court sided with Hopkins in this case. The next two cases further the changes in perception of Title VII in different lawsuits later in history. These go based off of court decisions made in previously historic cases, but also further changes the way that the courts look at Title VII as a law in the way that rulings are decided. The first one being Farragher versus the city of Boca Raton. In this case, there were female lifeguards working for the city of Boca Raton in Florida. Several female lifeguards reported sexual hostile atmosphere or sexual harassment to their supervisors, several supervisors, by one of their specific supervisors, and had reported that they were subjected to uninvited and offensive touching, lewd remarks, speaking of women in offensive terms, and other conduct that violates Title VII. This is a special case because the district court held that the city would be held liable for the harassment of the supervisory employees because the harassment was pervasive enough to support an inference that the city had knowledge or construct knowledge. The next case that's extremely important, once again, in sexual harassment, is Joseph Ancale versus Sundowner Offshore Services, Incorporated, also in 1998. This is a big case because the plaintiff is a male who is filing a lawsuit against another male for sexual harassment. The case went in the favor of the plaintiff, of Joseph Ancale, because the Title VII does not specifically distinguish sex being against the opposite sex. In this case, it can apply to men as well as women, and this was the first case in history that this was brought up in the court, and where the court sided with the plaintiff. We're now going to look at some important cases of the modern age regarding Title VII in the Civil Rights Act of 1964. The first being the EEOC versus Abercrombie and Fitch back in 2015. Some of us might know this case. It's a pretty high-profile one regarding discrimination of religion against religion. Samantha Eloff is a practicing Muslim and is suing Abercrombie and Fitch because she's claiming they did not hire her because she was wearing a headscarf because of her religion in the interview process. Abercrombie and Fitch argues that they didn't know she was a Muslim. She never told them they were a Muslim, and that was their main argument during the case. However, the courts did side with Samantha in the end because they claim that an employer may not make an applicant's religious practice, confirmed or otherwise, a factor in any employment decisions. The next case is Ellingsworth versus Hartford Fire Insurance. This is a case where Mary Kate Ellingsworth worked as a customer service rep for the company. She is a heterosexual female married to a man. However, at some point in her employment, her supervisor began repeatedly harassing her, saying that she dressed like a quote-unquote dyke. She was making fun of her attire, was telling Ellingsworth's coworkers that she had a lesbian tattoo, and even went as far as to say that she was an outright lesbian. Based on all this, Ellingsworth coworkers began to think she was gay, and Ellingsworth felt compelled to explain her sexual orientation to them, which caused her to be depressed and have anxiety, and she eventually quit. The company moved to dismiss the case, arguing that Title VII does not prohibit discrimination based on sexual orientation, let alone perceived sexual orientation. However, in the end, the court sided with Mary Kate Ellingsworth, saying that it wasn't a case of discriminating against perceived sexual orientation, but it was a case discriminating against gender stereotyping, which is one of the first cases to come to that ruling based on violation of Title VII. Not only can you not discriminate, you cannot hire someone just because they're a woman or just because they're a man, but you also, in the terms of sexual harassment, you can't discriminate or harass someone based on gender stereotyping. And then the last case that is very recent and is a big step forward from where the Title VII Act originated. This is also a sexual harassment or a lawsuit based on gender and sexual orientation. The plaintiff, Donald Zarda, filed a lawsuit against his former employer, alleging that the company violated the Civil Rights Act by discriminating against him because he was gay, because of his sexual orientation. Originally, the court did not side with him back in 2017, saying that discrimination based on sexual orientation was not prohibited by Title VII. It didn't specifically say in the Title VII or the Civil Rights Act of 1964 that it was prohibited. However, on February 26, 2018, in a 10-3 decision, the Second Circuit Court of Appeals ruled that discrimination on the basis of sexual orientation violates the Civil Rights Act of 1964. So now officially, it is a violation if you discriminate against someone based on their sexual orientation, which is has never been done before. This is very recent and a very big update of Title VII. Thank you for watching my presentation on Title VII of the Civil Rights Act of 1964. I hope everyone learned a lot and learned how the laws have changed throughout the years in different cases, and just learned a little bit of information regarding Title VII. But thanks again for watching, and have a good one.